I am Jean Pierce, co-chair of the League of Women Voters of Illinois Issues and Advocacy Committee. I would like to welcome the people who are spending this hour with us. We're recording this program so that people who were not able to join us now will have the opportunity to see it later. Captions have been enabled. If you would like to see them, please click on the transcript box with the two little C's or click on More and follow the directions. Now, Kathy Kinney, LWVIL Vice President of Voter Service, will open our program with a statement about the centrality of voting rights to the League's mission.
Thank you, Jean, and welcome Martha Kinsella and the Brennan Center for Justice and all attendees. The League of Women Voters has been committed to protecting voting rights for over 100 years. Voter access has not always been available to everyone, and voting is still inaccessible to many. The League works to improve access to the franchise because many citizens still must overcome obstacles that others do not have. With our collective commitment to voter rights, we continue to remove barriers such as disabilities, work schedules, ID requirements, limited voter registration, voter intimidation and deception, and voter purges. To ensure the continued existence of the right to vote, that right needs to be exercised, or we are ceding democracy to the few. That's why the League works for higher voter turnout at each election. That's why the League not only fights for voter access, but works with our election authorities and others to make sure those rights are implemented. That's why the League educates voters through our nonpartisan forums and Illinois Voter Guide, so voters have a reason to vote. And that's why the League trains a nonpartisan core of observers who attend all levels of monthly government meetings, so voters know how those elected officials are performing. Empowering voters, defending democracy. This has been our League of Women Voters motto for many years. What one issue is more important than this motto? If we do not empower voters, we are not defending democracy. If we are not defending democracy, we cannot hope to pursue the resolution of our many issues. We empower voters by educating voters. We empower voters by fighting all forms of voter suppression. When we stop fighting voter suppression, we stop defending democracy. Let's choose to educate. Let's choose to fight all forms of voter suppression. Thank you. Jean?
Thank you, Kathy. We're thrilled that we're joined today by Martha Kinsella, an expert who has been closely monitoring the progress of voting rights legislation and is highly qualified to share her insights about the path forward to passing them. Martha is a senior counsel in the Brennan Center's Democracy Program. She works on governmental reform, voting rights, money in politics, government ethics, and regulatory issues. She's authored several nationally recognized reports. Her work has been featured in press outlets across the country. She provides advice to federal lawmakers and executive branch policymakers. I will interview Ms. Kinsella while redistricting issues specialist Paula Lawson monitors the chat for questions that you submit. Paula will pose your questions at the end of the interview. So here's the first question. Please start with a brief description of the content of the Freedom to Vote Act and the John Lewis Voting Rights Act and tell us why they are needed.
Hi, Jean. First, I wanted to say thank you so much for holding this event and for the warm welcome. And I wanted to also say that Kathleen's introduction about the League's mission was very inspiring, and I agree wholeheartedly. I wanted to say also that the very first place where I ever voted when I turned 18 was in Illinois. So it's a special pleasure to be speaking to this audience. And I remember that when I changed my voter registration from Illinois back to New Jersey, my home state, that it was more complicated when I was back in New Jersey than when I registered to vote in Illinois. The other thing I wanted to say before getting to your question is that I'm especially pleased to be attending this event because this is actually the third time that I have been invited to speak to a chapter of the League of Women Voters. But the first time a few years ago, the event was canceled due to a snowstorm. It was an event in the Albany region of New York in January. So not too surprising that there was a snowstorm then, as there tend to be in January in parts of Illinois, at least as well. And then the second time that I was invited to speak, the event was canceled due to the beginning of the pandemic. So I'm very pleased that now, even virtually, the third time's the charm. So to address your question about the For the People Act, the Freedom to Vote Act, and the John Lewis Voting Rights Advancement Act, the For the People Act, which was HR 1 and S1, is landmark democracy reform and anti-corruption legislation. It passed the House of Representatives in March of this year. It would make it easier to vote in federal elections, end congressional gerrymandering, overhaul federal campaign finance laws, increase safeguards against foreign interference, and strengthen government ethics rules. The Freedom to Vote Act, introduced in September of this year, incorporates most of the critical provisions from the For the People Act, including automatic voter registration, early voting, vote by mail, and redistricting reform. It also includes much needed safeguards against attempts to undermine the electoral process. And the Freedom to Vote Act came out of an announcement in June of this year that Senator Manchin would not be supporting the For the People Act and that there were certain priorities that he wanted to see in voting rights legislation. So the Freedom to Vote Act is the product of his work and compromises with other senators. But as I said, it does still include many of the core features of the For the People Act. So in some ways, the Freedom to Vote Act is narrower, but in other ways, it includes new and updated safeguards for voting rights and election security that have been raised since the For the People Act was first introduced back at the beginning of this Congress. For example, the initial For the People Act had provisions guarding against voter suppression, but it did not respond to new tactics that we've seen since the 2020 election and over the course of 2021. In terms of election security, these were attacks on election officials and fake, quote unquote, audits of election results. The new bill has provisions that restrict election officials' removal without cause and that impose stronger protections for federal election records. In terms of voting rights, there were efforts to ban the distribution of food and water to those waiting in long lines to vote. Provisions included in the Georgia voter suppression bill, for example, and that's something that the Freedom to Vote Act addresses. On the other hand, the Freedom to Vote Act is very much compromise legislation that reflects important concessions responsive to critics of the For the People Act, including both Republicans and moderate Democrats, such as Senator Manchin. It also incorporates extensive feedback from election officials and others who advocated to preserve sufficient flexibility for states to tailor election practices to their individual circumstances. And it's certainly important to have buy-in from election officials. So although a number of provisions have been modified, there are not that many cases where provisions have been wholesale dropped from the For the People Act to the Freedom to Vote Act, which is definitely important to keep in mind. Turning to the third bill, the John Lewis Voting Rights Advancement Act. This bill would strengthen the Voting Rights Act of 1965, which is a critical bulwark against racial discrimination in our voting system that the Supreme Court has dealt 2 blows in the last 8 years. The first was Shelby County v. Holder. And to provide some background on the Voting Rights Act, there's a coverage formula in Section 4B of the Voting Rights Act, which determines the jurisdictions that are covered by Section 5, the provision that allows for DOJ scrutiny or pre-clearance of any election law change to make sure that it's not discriminatory before it goes into effect. So the Supreme Court in Shelby County in 2013 ruled that the coverage formula was unconstitutional on the grounds that it was outdated. And so that has meant that Section 5, the coverage section, is inoperable since Congress hasn't enacted a new coverage formula responsive to the Supreme Court's decision. So then the second case that chipped away, or more than chipped away at the strength of the Voting Rights Act, is a case from earlier this year, Brnovich v. Democratic National Committee, in which the Supreme Court made it more difficult to challenge discriminatory voting laws in court, introducing new factors into the analysis that have no statutory basis, such as whether a state provides more opportunities to vote now than most states did when Section 2 was last amended in 1982. So the John Lewis Voting Rights Advancement Act would undo a lot of the damage that the Supreme Court has done to the Voting Rights Act. It updates the coverage formula in a manner responsive to the Supreme Court's ruling in Shelby County. And with at least 19 states passing 33 bills this year, making it harder to vote, many of them targeting voters of color, the Freedom to Vote Act and the John Lewis Voting Rights Advancement Act couldn't come at a more critical time. These state voter suppression bills are exactly what the Voting Rights Act pre-Shelby County would have stopped. And the Freedom to Vote Act and the John Lewis Voting Rights Advancement Act can help address racial disparities in voting. Turnout for non-white voters is substantially lower than for white voters. For instance, in 2020, only 58% of non-white voters participated compared to 71% of white voters. The gap is even more stark in states that are likely to be covered under the John Lewis Voting Rights Advancement Act, and it's grown dramatically since the Shelby County ruling. And as we enter a new redistricting cycle, there are already signs of gerrymandering targeting communities of color. Without pre-clearance, states pass new voting restrictions as older ones are struck down, and that's why a new coverage formula that can withstand Supreme Court scrutiny is needed. That's why we need the John Lewis Voting Rights Advancement Act. And we need federal standards that would preempt and counteract many of these voter suppression laws to stop them before anyone even starts drafting them. And that's why we need the Freedom to Vote Act.
So thank you. We understand that there are differences between the Senate version of the John Lewis Act from the House version, and then there was a compromise version submitted on Tuesday. Could you give us an idea of how the most recent Senate version differs from the House version?
Certainly. So if you did a side-by-side comparison, you'd see that the bills have language differences. For instance, the coverage formula in the Senate version, the version from earlier this week, has some differences from the House versions. But in the main, the two versions aim to achieve the same ends, which are to safeguard against racial discrimination in voting rights in a manner that is responsive to the Supreme Court's recent decisions. The Senate version was crafted bearing in mind the path to passage required by existing Senate rules. Importantly, none of the components of the House version of the John Lewis Voting Rights Advancement Act were taken out. And in fact, the Senate version incorporates two new provisions. First, the Election Worker and Polling Place Protection Act, which creates new protections for election workers. And importantly, it also includes the Native American Voting Rights Act, which Senator Murkowski was instrumental in including. For these reasons and more, the Voting Rights Advancement Act, both House and Senate versions, is really important, and it needs to move with the Freedom to Vote Act. And it's a top priority. This week, we saw that the Voting Rights Advancement Act gained bipartisan support. All 50 Democratic senators support it, as does Senator Murkowski. And while there are certainly some differences between the House and Senate versions, passage of the bill would be a significant step forward in the fight to protect voting rights, especially if coupled with the Freedom to Vote Act.
So you mentioned that some of the provisions were modified in the transition. Are any of these, so some stuff was lost in a sense when the For the People Act became the Freedom to Vote Act. Are these things being addressed in other bills?
So I will say that the Freedom to Vote Act contains many of the provisions of the For the People Act in modified form, sometimes even stronger. And then there are also there were, I guess, the one section that was fully removed from the For the People Act and doesn't have any parallel or analogous provision in the Freedom to Vote Act is the ethics section of the For the People Act. And that has not found a new home yet. One provision of the ethics section, tax return disclosure for presidents and presidential candidates, that has been moved into an omnibus government ethics bill addressing abuse of executive power called the Protecting Our Democracy Act. But the other provisions haven't found a home yet, but we're definitely optimistic that they will land somewhere. With respect to the changes between the For the People Act and the Freedom to Vote Act, so in many cases, as I was saying, after consulting with election officials, flexibility was introduced into the Freedom to Vote Act. So for instance, with respect to automatic voter registration is definitely in the Freedom to Vote Act, but it gives states more flexibility. So where the For the People Act would have required many agencies to offer automatic voter registration as part of their services, the Freedom to Vote Act only requires states to offer automatic voter registration at their DMVs. It still provides funding to states that want to provide AVR at other agencies like housing or health agencies, but it's only required at DMVs. With respect to voting by mail, the Freedom to Vote Act retains the requirements that all states allow no excuse mail voting and that they offer several ways to return ballots, but it omits the For the People Act requirement that election officials distribute mail ballot applications to all registered voters. It requires any state with a voter ID requirement to accept many forms of ID. And in this case, this was directly inspired by Senator Manchin's experience as Secretary of State of West Virginia, where they have a very liberal standard for voter ID. So the Freedom to Vote Act voter ID provision really reflects his experience in West Virginia. The bill also provides that voters without ID can vote provisionally and verify their identity, again, similar to how things work in West Virginia. As a reminder, the For the People Act would have required that any state with a voter ID requirement let registered voters cast a regular ballot upon signing a written statement attesting to their identity. So that is one difference. The new bill also allows for states to have mail ballot voter ID requirements, but ones that are not more restrictive than in-person ID requirements, whereas the For the People Act would have required any state with a voter ID requirement to let registered voters cast a ballot upon signing an attestation of their identity. With respect to voter purges, where the the For the People Act had stringent standards to prevent unlawful voter purges, that is a bit relaxed in the Freedom to Vote Act, in that it allows states to mark voters as ineligible, but only based on objective and reliable evidence, and restricts faulty methods and requires notice and opportunity to voters to show eligibility. With respect to provisional ballots, whereas the For the People Act would have required states to count valid ballots cast anywhere in the state, that is somewhat narrowed in the Freedom to Vote Act, requiring provisional ballots cast in the wrong precinct only if cast in the correct county. With respect to redistricting, the For the People Act banned partisan gerrymandering for congressional redistricting and required the establishment of independent redistricting commissions. The Freedom to Vote Act does not include a provision about independent commissions, but it actually strengthens the ban on partisan gerrymandering. So that's one instance where not only does the bill address the same issue, but it actually strengthens it in some ways. With respect to campaign funding, there were some substantial changes between the For the People Act and the Freedom to Vote Act. So whereas the For the People Act would have created a small donor matching system for all federal elections, the Freedom to Vote Act makes funds available only for House races in states that choose to opt into the program. And states that don't opt in can use the funds for other election-related purposes. There have also been some changes to other campaign finance provisions from the For the People Act to the Freedom to Vote Act. So campaign finance disclosure requirements, for instance, the For the People Act would have overhauled, so the Freedom to Vote Act has a number of critical disclosure requirements. One would force any entity spending over $10,000 in an election to disclose all of its donors. And another provision would tamp down on election-related misinformation by requiring online political advertisement platforms to disclose who is buying ads on their platforms. But this is somewhat scaled back from all of the disclosure requirements that were in the For the People Act. And whereas the For the People Act would have overhauled the Federal Election Commission, changing the composition so that it wouldn't deadlock with the equal bipartisan composition, the Freedom to Vote Act's reforms are not as extensive, but are still significant. So while the Freedom to Vote Act wouldn't change that bipartisan composition 3 and 3 that often leads to gridlock, it would change enforcement procedures, which would hopefully reduce the effect that the partisan gridlock has in blocking investigations of alleged violations. So to take a step back, the Freedom to Vote Act still moves the ball forward on many key issues, and it's our best bet for making progress on these issues right now.
Thank you. You talked about redistricting. As you may know, Illinois has really resisted having an independent commission handle redistricting, and of course that's been changed in the mutation between these bills. And in fact, the maps drawn for our General Assembly were recently thrown out by a court. Do you, in your crystal ball, do you see is redistricting likely to remain in the Freedom to Vote Act?
Yes, so the redistricting provisions of the Freedom to Vote Act are likely to stay in. As I mentioned, the Freedom to Vote Act does not include a provision for independent redistricting commissions, but it does have, in some ways, stronger safeguards against partisan gerrymandering with specific court enforceable standards, such as a requirement that states use modeling to address partisan fairness, added protections for communities of color, and new requirements to be open and transparent.
Do you think it's likely that the Freedom to Vote Act will be passed too late to affect redistricting for the next election?
That's a good question. So we, with respect to timing, it's absolutely not too late. In fact, there's language in the Freedom to Vote Act that makes clear that it applies to all congressional maps drawn this cycle. So whenever it passes, it'll apply. The reality, however, is that the longer you wait, the messier it becomes. Lines get drawn, people announce that they're running. So time is of the essence, even though there is language in the Freedom to Vote Act that would allow for kind of retroactive application. But it just underscores the urgency that we need to get this legislation passed.
You mentioned the gap in racial turnout. How would passage of these bills address that gap?
So the growth of the racial turnout gap, particularly in states previously covered by the Voting Rights Act has been very concerning. As I mentioned previously, on the one hand, the 2020 elections were exciting because we saw high turnout for both the entire electorate as well as for each racial group. More Black Americans voted in 2020, for example, than any presidential election since 2012. But that masks a huge gap. This disparity of 70 or 71% of white voters casting a ballot last year versus 58% of non-white voters. So what's more is that this turnout gap is larger than it was in 2012 before the Shelby County decision, really underscoring how powerful the Voting Rights Act of 1965 was before the Supreme Court issued these decisions. We might remember that in 2013, after seeing evidence that the turnout gap had narrowed in prior years, the Supreme Court used this as evidence to justify gutting key parts of the Voting Rights Act. And Justice Ginsburg's famous line about throwing out your umbrella when it's raining because you aren't getting wet. But since then, we've seen these turnout gaps grow concurrent with a growth in restrictive voting access legislation, especially in states that used to be covered by the Voting Rights Act Section 5 preclearance. This is even more concerning following the Supreme Court's recent decision in Brnovich, which further weakened the Voting Rights Act. So the John Lewis Voting Rights Act, Voting Rights Advancement Act, is designed to re-implement and refine the protections of the Voting Rights Act that the Supreme Court has stripped away. And one way is by restoring preclearance to jurisdictions where discrimination is most prevalent, doing so in a targeted way that passes the constitutional standards laid out in Shelby County. Preclearance would require jurisdictions to have their changes to voting laws approved by the Department of Justice or a court before they go into effect. And this process would prevent discriminatory or suppressive policies from being implemented in the first place, because often voter suppressive legislation goes into effect and remains in effect until court challenges are completed, which can take many election cycles. Also, as I mentioned previously, the Senate version contains the Native American Voting Rights Act, which is another way to address the racial turnout gap. So for these reasons, the Voting Rights Advancement Act is an important step to address the racial turnout gap, but it's not the only measure available to address this issue. The Freedom to Vote Act is another really critical component here. As mentioned before, the Freedom to Vote Act has numerous provisions that make it easier for people to vote, and in doing so, address the racial turnout gap, such as no excuse absentee voting, allowing for alternative forms of ID in states that have ID requirements, requiring some form of automatic voter registration in every state, requiring states to offer same-day voter registration, and research definitely shows that restrictions on absentee voting and voter registration, as well as voter ID laws, lead to racial disparities in voter participation. So these provisions would really help to close the racial turnout gap. For another thing, the Freedom to Vote Act would crack down on deceptive and intimidating practices that suppress the vote, often on racial lines. And it has provisions to counter long lines and discriminatory practices. As we've seen, Black and Latino neighborhoods are most often subject to long lines on election day, which leads to suppressed turnout. And the Freedom to Vote Act requires states to ensure that lines are no longer than 30 minutes long, and it prevents states from prohibiting donations of food or water to people who are waiting online to vote. So these two bills together really, each one is a very powerful tool to address the racial turnout gap, and together they're even more powerful in combating that issue.
So recently, we've seen a lot of posturing regarding the infrastructure and Build Back Better bills. So considering issues that have been encountered in the process of trying to pass those bills, what implications do you see for passing voting rights bills?
That's a great question. So the one thing I'll say off the bat is that the situation is different here with these voting bills as compared to the infrastructure bill. Whereas the Democratic caucus hasn't solidified around the infrastructure bill, here Senator Manchin has taken the lead on both the Freedom to Vote Act and the John Lewis Voting Rights Advancement Act. There's now bipartisan support for the VRAA, and also the Senate rules at play are different. Spending bills can go through the budget reconciliation process, which has actually, even though it's a lower threshold for passage, it's created an incentive to cram as much in as possible, which brings big price tags each time. And although the infrastructure bill and democracy reform legislation are both urgently needed and they're top priorities for the president and congressional leadership, the external pressures and timelines are different, with redistricting being in the mix. If anything, the way that the infrastructure fight has played out underscores the need for democracy reform because it reflects the brokenness of our governance system and the need to improve democratic accountability. Polling consistently has shown majority support for both the bipartisan infrastructure bill and the president's more expansive infrastructure plan, but it hasn't gotten done. So to me, that really underscores why we need structural reforms, democracy reform to make sure that we have greater accountability and a stronger representative democracy. The same can be said for democracy reform. The legislation is popular, it's got bipartisan roots, and we need it desperately to fix our broken government and restore public trust. It's the right thing to do to ensure that we have a representative democracy.
We couldn't agree more. But in the worst case scenario, supposing these bills don't pass, people will surely be discouraged about voting in the next election. Are there other ways of addressing the voter suppression bills that have been passed in these 19 states recently?
So, certainly it would be very discouraging, but as we've seen before, people go to extraordinary measures to vote. And to be clear, they shouldn't have to. But one of the most effective ways to communicate the continuing necessity of democracy reform to lawmakers is through participation in the electoral process. We can't give up at the ballot box. We have to vote for people who support democracy reform and hold them accountable. So if these bills don't pass, voting rights advocates will keep fighting. We've seen that before. And it is going to be even more of an uphill battle as more and more anti-voter bills are passed into law. That being said, we're really close to getting the most significant democracy reform in more than half a century. We're within striking distance. If the votes on the bills in Congress weren't a clear enough signal, we know that this is true because, as Jane Mayer reported several months ago, the Koch network has been organizing aggressively against democracy reform, which has broad support, including among Republicans. So that's why we have to seize this opportunity. The Brennan Center believes that both the Freedom to Vote Act and the John Lewis Voting Rights Advancement Act are still the best opportunities that we have right now for passing election, campaign finance, gerrymandering, and voting rights reform. We're at the compromise. Just this week, we saw bipartisan support emerge for the John Lewis Voting Rights Advancement Act. We have to keep the pressure on that this is possible and that it's achievable and it's necessary and it has to be done now. Bills take an average of 8 years from incubation, ideation to passage. So we kind of can't go back to square one now. We have something that's very strong, that's got momentum, and we need to keep pushing. It's hard to see parts of this bill passing piecemeal if the whole thing doesn't pass, and one uniform bill really is better. We need these reforms to happen simultaneously if we're really going to address the crisis in our democracy. We need voting rights protections. We also need campaign finance reform. We need to address partisan gerrymandering. These things, you need all of them together in order to really address the crisis that we're facing. And it's really up to Congress to act at this point. There are things that the executive branch can do, but that's more limited. It's limited by the courts and what Congress has authorized the executive branch to do. And courts have shown that they're less and less willing to intervene. There are positive signs politically. Senator Murkowski supports the Voting Rights Advancement Act, as do Senator Manchin and all other Democrats. President Biden has expressed support for Senate rules changes to get this done, and all of the Senate Democrats support the Freedom to Vote Act. Senate Majority Leader Schumer has said that failure is not an option, voting is too sacred. Senator Manchin has similarly said that inaction is not an option. And with redistricting underway and restrictive voting laws being introduced and passed in states around the country, now is really the time to act. That being said, we've also seen that in the absence of federal legislation, state and local governments can lead the way in developing policy that later gets adopted around the country and eventually makes its way into federal legislation. For instance, state level automatic voter registration laws and policies launched AVR into the mainstream. Same with redistricting commissions and small donor public financing legislation. Change can happen very slowly, and things can often look bleak before they get better. I'm personally a student of the New Deal era. People who wanted to transform America to build a social safety net and combat economic inequality faced many defeats, particularly in the Supreme Court, before there was a change for the better. It took decades of progressive organizing, legal scholarship, state level reforms, and electoral victories before a fundamental shift occurred in the structure of government and its relationship to the American people. And I believe that a similar shift can happen again. Indeed, it must. Defeat or inaction can't demoralize us, and instead it needs to solidify our resolve.
The League is in full agreement with you. I just got a notice that the Justice Department just filed suit against Texas's voting rights restrictions. What is the path forward for passing voting rights legislation in light of the filibuster? Why have senators been reluctant to change the rules?
Well, perhaps you saw the news today that Senator Carper is the latest senator to support a rules change for democracy reform legislation. As several senators have articulated, they believe that the filibuster preserves some balance, protecting the rights of the minority. But I think we need to keep in mind that the filibuster is not a binary. You can combine the ideals of proponents of the filibuster who have those concerns about bipartisan buy-in with a functioning Senate. In fact, the filibuster has been reformed 161 times between 1969 and 2014. Senator Manchin himself did it in 2011. There are all sorts of exceptions to the filibuster today, from reconciliation to appointments for executive branch and judicial nominees. So the Senate needs to get democracy reform done. That's been clear both from Senate Majority Leader Schumer's statement as well as Senator Manchin's statement. And it's up to them ultimately how to do this, what they're comfortable with. There are reasons for optimism that something will get worked out. The Freedom to Vote Act and the Voting Rights Advancement Act are moving along. If we think about where we were this summer with Senator Manchin announcing that he would not support the For the People Act, and then he rolled up his sleeves and took a leadership role in drafting the Freedom to Vote Act, which would still be the most comprehensive democracy reform legislation in nearly 60 years. Some provisions, as I've mentioned, are stronger than the For the People Act, and others reflect the concerns of election officials. And as I said earlier, buy-in from election officials really is critical for legislation to be successful. And it's not just his priority, it's really his legacy. There's no reason to think that he'll just let the bill die after putting in all of this work. Next, he tried to get Republican support for the bill. With so many components of the bill having garnered bipartisan support in the past, this was not a fool's errand. And with respect to the John Lewis Voting Rights Advancement Act, he expressed support for that legislation back in June. He's supported it in the past, and just this week, he got Senator Murkowski on the bill. So while it may seem like things have stalled, from another perspective, they're actually moving, and now we just have to get it over the finish line. It's the president's priority, it's the party's priority, it's Senator Manchin's priority. As for procedural hurdles and loopholes in the Senate, there are several paths available, including those that would preserve the deliberative process that Senator Manchin is committed to. He is a master of the Senate. He probably knows better than almost anyone how to get this done. And the pressure is building. President Biden is on record saying that we need to reform the filibuster. And while several senators are reluctant to abolish it in its entirety, there does seem to be a growing consensus that reform is needed in the Senate, as evidenced by the announcement today from Senator Carper. So it remains to be seen which path is taken, and there are several paths available. And it's, I think, ultimately really up to the senators themselves to figure it out, considering all of the signs that we've gotten from Senator Manchin, from Senator Schumer, and the White House, making clear that inaction is not an option.
I appreciate your optimism. Now, Paula Lawson will ask questions submitted by League members.
Okay. I think you were just talking about the filibuster, and maybe it needs a little bit more clarification. Somebody asked why senators seem to be reluctant to change the filibuster rules.
I'm by no means a mind reader, but I think that there is a sense that there are some virtues to the filibuster, that it preserves the deliberative process, or kind of thinking about when the shoe's on the other foot, when the power changes in the chamber. But we've also seen many exceptions to the filibuster implemented over the years. I think that it's ultimately up to them to figure out what they're comfortable with, but they've certainly made exceptions and changes to the rules over the years.
Okay. Somebody else asked, if all 50 Democratic senators plus Murkowski support the John Lewis Voting Rights Advancement Act, how come it's not moving forward immediately? So.
I believe that's because the Republicans have said that they're going to filibuster. To be honest, I am not a student of the Senate rules in general, but yeah, I believe that it's because the Senate minority said that they would filibuster the legislation, and they don't have the votes to break the filibuster, which, that threshold would be 60 votes.
Right. Then we have a question that goes back to, I think I have to go back to the top here. You talked about Murkowski supporting the John Lewis Voting Rights Advancement Act. There's a question, do any Republicans support the Freedom to Vote Act, and any chance that it will pass in the Senate?
The Freedom to Vote Act does not currently have any Republican support. It just has the full support of the Democratic caucus in the Senate, and most likely there would need to be a change to the rules for it to pass at this point, without support from from anyone on the Republican side.
Okay, and then they just asked really the same follow-up, do any Republicans support any of these bills? So other than Murkowski, is there anybody that you see that might at this point?
I can't predict whether it will change, but currently Murkowski is the only supporter of the John Lewis Voting Rights Advancement Act, and there are no Republicans on the Freedom to Vote Act. That being said, as I mentioned previously, there are many components of the Freedom to Vote Act that have had bipartisan support in the past or come from red, blue, and purple states. And so there is a bipartisan history, certainly, to the reforms in the bill.
Okay.
Paula, have we answered the questions in the chat? I wanted to remind people to put questions in the chat. Were there any others that we haven't answered yet?
There really weren't any. We have one that's on a slightly different topic here. And it's really more about campaign finance or corruption laws. It says, why hasn't the role of corruption been emphasized more? I guess in these Voting Rights Act laws, more in the case of Manchin and Sinema. This person's concerns raised concerns of conflict of interest regarding infrastructure and Build Back Better provisions. Okay, so really the question is, why hasn't the role of corruption been emphasized more in these bills? And you might have already talked about that.
Yeah, so the Freedom to Vote Act, I think one of the most substantial changes from the For the People Act was the removal of the ethics provisions, and then also a softening of the campaign finance reform provisions. That being said, the provisions on campaign finance reform in the Freedom to Vote Act are still a tremendous improvement over the status quo, and would really help to make the regulatory agency that oversees campaign finance law stronger, and would also increase disclosure requirements and provide access to funds for House races for the states that opt into that program, which would be powerful in combating the role of big money in our political system. I don't actually know the answer to the question why those changes were made in particular. With respect to, I guess, maybe the narrative around this bill or these bills, I think that there are very many supporters of these bills who come from many different backgrounds, from voting rights and civil rights to good government types. And I think that there has been messaging on all of these issues throughout the long journey that first the For the People Act took, and now the Freedom to Vote Act is taking. I actually heard or saw polling fairly recently that showed that the narrative of corruption, combating corruption, is really very powerful with voters. So I do think that there's something there to this question, and I think that the Freedom to Vote Act is an important first step in combating a lot of those problems with corruption specifically, and conflicts of interest among elected officials. But I think it's also a sign that there is potential momentum for future legislation even stronger in this vein. And as I mentioned, we are hopeful that the ethics provisions of the For the People Act will get incorporated into something else, or will become their own legislation. We'll have to see. The one provision that has made it into another bill, the Protecting Our Democracy Act, that bill definitely has many anti-corruption provisions in it. For instance, a codification of the emoluments clauses of the Constitution to make them actually enforceable. So there's a common thread throughout many of the provisions of that other bill, of kind of reining in abuse, holding government officials accountable, And that bill is kind of thought of as like the third in the trilogy of the Freedom to Vote Act, the John Lewis Voting Rights Advancement Act, and then the Protecting Our Democracy Act as the three pillars to really restore democratic accountability in the federal government.
Is there any way of moving these voting rights bills through budget reconciliation? Or is that too much of a stretch?
I remember attending a meeting where we were discussing that. I think because they don't have a price tag in most cases, they can't. Interestingly, this was a point, it's not my own idea, but I heard it from someone else that because of the various exceptions to the filibuster that exist, budget reconciliation being one of them, spending bills can go through that route, and then the filibuster ends up being in place for voting rights and civil rights legislation that can't go through budget reconciliation. So there are certain things that kind of meet the filibuster, and others that can go through the budget reconciliation process. And unfortunately, I don't think that these bills can go through that route.
Okay. There's a couple more questions in here. What are the debate points about federal oversight over elections versus states' rights?
So I think that's certainly a talking point, and that's something that's somewhat addressed by the Freedom to Vote Act by giving more flexibility to the states in the implementation of for instance, automatic voter registration or voter ID, that the For the People Act certainly was within the federal government's constitutional authority to impose standards across the board for federal elections. But the Freedom to Vote Act kind of addresses some of those concerns about kind of uniform federal standards by allowing more flexibility and really taking into account feedback from election officials at the state and local levels.
Okay. I think we have time for about a couple more questions. Can you speak to the positive results for voter rights in individual states that are not being covered in the news as much? So what's a good that's going on?
Well, I guess one thing is that more and more jurisdictions are implementing small donor public financing systems. So Washington, D.C., where I live, and many of the surrounding counties have implemented small donor public financing systems that either are in effect already or will go into effect in the next couple of years. I think also that many of the provisions of the For the People Act and the Freedom to Vote Act have become sort of the gold standard in many jurisdictions across the country. Again, living in DC, I think really very many of the policy proposals that are in the voting sections of the For the People Act and the Freedom to Vote Act are implemented here. Yeah, there definitely are a lot of positive changes at the state and local levels across the country in various jurisdictions. I remember before the For the People Act was introduced in the last Congress in 2019, that many of my colleagues were working in many states all across the country to implement many of the policy proposals that ultimately made it into the For the People Act. So that's definitely a positive.
Okay. Another question is, we are facing increasing loss of faith in our election process. What resources does the Brennan Center have to help the league counter claims of election fraud, disinformation? And what are some of the Brennan Center's key initiatives?
So this is the work that a number of my colleagues do, but I am not directly involved in it. So I am speaking as somewhat of an outsider. My apologies. But with respect to election security, my colleagues are big proponents of risk limiting audits. And then my colleagues also work on responding to the quote unquote fraud in Arizona. And that's kind of cropping up in other places around the country. They've also done a lot of work to provide support for election officials. They released a report fairly recently about attacks on election officials and really making the case for supporting and strengthening election officials and the resources that they need to do their jobs. So those are some of the issues that they take on. With respect to disinformation, that's also something that, that my colleagues work on, and something that the For the People Act, and I think to a lesser extent, the Freedom to Vote Act would be responsive to as well. For instance, like requiring disclosure of information with respect to political advertising.
Okay. What reasons do Republican senators communicate to their state constituents as to why they do not support these acts?
That's a great question, and something that I'm also not very familiar with. I do think, I'm not speaking about Republican senators in particular, but I do think that the big lie narrative is unfortunately very powerful. And while I'm not speaking specifically about elected officials, I do think that that's another reason why we really need the Freedom to Vote Act, is to counteract all of this misinformation, disinformation about like the illegitimacy of our elections, and when the reality is that we need to make it easier, not harder, for people to vote.
I think one last question is, what more can we do at this point to get these bills passed?
I think that keeping the pressure on and keeping the narrative that this is possible, that it's achievable, and that it's necessary, that's really important to get these bills over the finish line. And I think educating people, members, the general public, about how critical this legislation is. Sorry, I didn't mean to interrupt you.
No, I interrupted you. Thank you so much for sharing your expertise and your optimism with us today. We truly appreciate it. And I also want to thank all of our league members for staying engaged and informed. If your question wasn't answered, we'll try to provide answers in the future. So thank you to all of you, and have a wonderful day.
Thank you so much.